Hi, everyone, and welcome to today's Explainer. If you've ever tried to read through U.S. immigration law, it honestly feels a bit like trying to decipher a foreign language written in invisible ink. It is incredibly dense, it's pretty intimidating, and obviously the stakes are just extremely high. So today, our goal is to completely demystify one of the most absolutely crucial and, frankly, most misunderstood sections of the Immigration and Nationality Act, or the INA. We're going to break down this dense legal text of U.S. visa and eligibility, specifically focusing on the criminal grounds that can keep someone out of the country and the waivers that might actually let them in.
Okay, let's dive into this, because this right here is the fundamental question at the heart of today's explainer. Can a past mistake permanently lock you out of the United States? The Immigration and Nationality Act is essentially the ultimate gatekeeper for the country. And it doesn't just look at who you are today, right? It looks really deeply at your past. Section 221A(2) of this act is basically this highly sensitive alarm system that detects very specific past actions, and it decides right then and there if the gate swings open for you or if it slams shut forever.
So here is our roadmap for today. 1. The visa eligibility gate. 2. Crimes of moral turpitude. 3. Drugs, vice, and trafficking. 4. Exceptions for minor offenses. And 5. Applying for a waiver. Let's start with Section 1, the visa eligibility gate, passing through U.S. border security. Think of Section 212 sort of like a massive security scanner at an airport. But instead of scanning your physical luggage, it's scanning your historical luggage, your past actions, your criminal record, who you've associated with. The statute is incredibly clear here. Consular officers have very strict mandates. They literally do not have the luxury of just shrugging off a red flag. If an applicant is found ineligible under any of the grounds in INA Section 212, the visa absolutely must be denied. The law translates into a hard stop. If that alarm goes off, the officer's hands are totally tied. Moving right along to Section 2, Crimes of Moral Turpitude, this is really the foundation of 212A2A. So the law states that anyone convicted of, or who even just admits to committing a crime involving moral turpitude, is inadmissible. Now, what's really interesting about this is the specific carve-out the INA makes right in the definition. It explicitly excludes purely political offenses. Why does that matter? Well, it means if an authoritarian regime criminalizes a political opponent just for peacefully protesting, U.S. law distinguishes that from an actual crime of moral turpitude, like, say, fraud or violent theft. It's a really vital distinction that protects political dissidents while still keeping out folks who have committed inherently depraved acts. But you might be wondering, what if an applicant has a few lesser convictions that don't necessarily fall under that heavy moral turpitude umbrella? Well, the law actually has a mathematical formula for that, and it all comes down to the number 5. Under the multiple criminal convictions rule, if someone is convicted of 2 or more offenses, again excluding purely political ones, and the total aggregate sentences to confinement equal 5 years or more, they're inadmissible. It doesn't even matter if the offenses were from a single scheme or if they were all handled in a single trial. If that confinement math hits 5 years, boom, the gate drops.
Which brings us to Section 3, Drugs, Vice, and Trafficking. These are the severe categories of inadmissibility.
So, well beyond your basic criminal convictions, the INA targets highly organized, really severe illicit activities. We are talking about controlled substance traffickers, anyone engaged in prostitution within the last 10 years, money launderers, foreign government officials responsible for severe violations of religious freedom, and human traffickers. These heavy legal subclauses act as distinct, immovable pillars. If an applicant is tied to any of these categories, it's a major, absolute block to entering the United States. No way around it.
But get this, the law casts a much wider net than you might expect. It's not just the primary offender who gets blocked. The statute explicitly states that the spouses, sons, and daughters of human traffickers or controlled substance traffickers are also inadmissible if they obtained any financial or other benefit from that illicit activity within the previous 5 years. They basically just had to know, or reasonably should have known, where that money was coming from. Now, the only exception here is if the son or daughter was a child at the time they received the benefit. It's a pretty powerful tool designed to stop entire families from just kicking back and enjoying the profits of criminal enterprises inside the U.S. Let's look at Section 4, Exceptions for Minor Offenses. These are the safe harbors in the legal text. The law isn't entirely black and white. It actually recognizes that people, especially young people, make mistakes. And this brilliantly illustrates the 2 primary safe harbors for a single crime involving moral turpitude. First, we have the youth exception. If the crime was committed when the applicant was under 18 and it's been more than 5 years since the crime and their release from confinement, they get a pass. Second is the petty offense exception. If the absolute maximum penalty possible for the crime was 1 year or less, and the person was sentenced to no more than 6 months in prison, it won't automatically trigger a denial. These are highly specific safe harbors, right? They're crafted to prevent a minor youthful indiscretion from turning into a lifelong ban. And finally, Section 5, applying for a waiver, Section 212H, which is essentially the legal lifeline. So, to put this into perspective, drug offenses are usually an automatic, totally unforgiving ban, but the statute contains a highly specific metric. So the crucial point is this. Under Section 212H, the Attorney General actually has the discretion to waive inadmissibility for a single offense of simple possession of 30 grams or less of marijuana. Just 30 grams. Anything more than that, or literally any other controlled substance, and this specific waiver just does not exist. It really highlights how microscopic the legal text gets when it's dealing with exceptions. Now, to actually secure a 212H waiver for eligible crimes, you've got to meet some really strict conditions. You generally have to prove either that 15 years have passed since the activity and you've been fully rehabilitated, or that denying admission would result in extreme hardship to a U.S. citizen or permanent resident spouse, parent, son, or daughter. Alternatively, VAWA self-petitioners, so victims of battery or extreme cruelty, also have a pathway here. This matters immensely, folks, because it represents the law's attempt to actually balance strict border security with family unity and deep humanitarian concerns. Actually, scratch that. Before we get too optimistic about waivers, we have to contrast those legal lifelines with the absolute, unwaivable blocks. The INA draws a very hard boundary right at the end of Section 212H. It explicitly states that absolutely no waivers shall be provided in the case of someone convicted of or who admits to committing murder or criminal acts involving torture, or even just an attempt or conspiracy to do so. No matter how much time has passed, no matter the hardship to a U.S. family member, for these specific atrocities, the door remains permanently locked. Which brings us to the end of our journey through this incredibly dense legal framework, and it kind of leaves us with a lingering question. Do these super strict rules perfectly protect a nation by filtering out genuine threats, or do they inadvertently punish fully rehabilitated lives for mistakes made decades ago? INA 212A2 is just this fascinating, rigid, yet slightly flexible machine that tries to define morality, criminality, and redemption on a global scale. Thank you so much for joining me on this explainer. I really hope this gives you a whole new lens through which to view the complexities of global borders. Keep learning, and I'll catch you.